No, I don't.
Fine.
Oh,
Okay, no.
I have it. I have it. All right. Ms. Gray, are you ready? Okay, Ms. Gray's ready. I'm ready then on Al-Rihani first. Mr. Houston, once you get the PSIR, I can send you and your client to a breakout room.
Okay. I'm still waiting on it, so.
Okay. Mr. Al-Rihani, please start your video. All right, make sure you're stationary, seated or standing in an upright position.
Good morning, Your Honor.
Good morning, sir. This is case number 234431001, the people of the state of Michigan versus Alan John Al-Rihani. The defendant is charged with 1 count of gambling to disassociate the person. Today is the date set for a pretrial conference. Appearances, please.
Good morning, Your Honor. Carmen Rankin on behalf of the people. I'm requesting permission to practice under Michigan Court Rule 8.120 and under the supervision of Alexandra Peterson. I'm currently a 3L at Wayne State University in good standing.
Permission granted.
Good morning, Your Honor. Nick Canal appearing on behalf of Alan Al-Rihani, who appears with us today on Zoom. Mr. Al-Rihani,
Your P number, counsel.
oh, I'm sorry, Your Honor, P number 78298.
All right. Now, Mr. Al-Rihani, you can state your name.
My name's Alan Al-Rihani, Your Honor.
And what's your middle name?
John.
Thank you so much. Today is the date set for pretrial conference. Counsel, how are we proceeding?
Your Honor, the last time we were here, we were exploring the option of diversion on this case. And I don't know if that's been approved or not. We were waiting. We were supposed to get my notes said we were supposed to get a email from the AG's office in regards to that. I never received anything. I don't know if they have an offer. If they do, that's great. We'd avail ourselves of it.
Ms. Rankin.
Yes, Your Honor. Currently, our office is under the understanding that Mr. Al-Rihani is eligible for diversion. We do want to note, though, that he does have a prior DPL, but he advised that he had not received diversion paperwork. So what we'd like to do is have him go ahead and complete and then diversion for that first one, and then go ahead and then plead guilty under a delayed sentence for the second.
So I'm sorry, help me understand. So are you saying that Mr. Al-Rihani currently has 2 open cases?
That's correct.
Consumer protection
And
practice, and then they'll be able to.
what's the status of this first? So this case right here is his second case.
That's correct.
And you're saying on the first case, which is not on my docket today, he's eligible for diversion.
Yes.
Okay, can I get the case number and status of the first case? Were you aware of another case, counsel?
I'm not aware of another case.
All right, let me see. Do you have the case number, madam?
Yeah.
Prosecutor, or what's the case number for the first case that's not on my docket today?
I can go ahead and pull that up. One moment.
May I say something, Judge?
No, sir. Hold on 1 second. Mr. Houston? Can you unmute? It should let you unmute.
Yeah, I'm sorry. My finger was missing the button.
You just haven't, your fingers swollen up? No, I'm just kidding.
Yeah.
Mr. Houston, did you receive the PSR?
I did, Your Honor.
Okay, so I can let your client, let me let your client in, and then I'll send you both to a breakout room.
Okay,
Unless
thank
you want, is that sufficient time? I mean, the court rule does say you get 2 days, so I don't know. Are you okay?
Yeah, it's fine.
Okay. Ms. Lumpkin, unmute and identify yourself, please.
Hi, Marsha Lumpkin, trying to get my video up.
It wouldn't let you. It was disabled. Now you can start your video, please. All right, Ms. Lumpkin, I'm going to send you to a breakout room with your lawyer. Mr. Houston, I'll send you both to breakout room number 10.
All right, thank you.
You're welcome. All right. Okay, counsel, what did you want to say?
I was just gonna say, if there was another case, shouldn't it have been resolved though? If it was from something that occurred before?
I mean, I don't know. That's what she's going to tell me. Matt, do
Okay.
you have the case number?
Yeah, I don't have the case number, Your Honor, but I do have a Michigan State Police incident number.
No, that's okay. Ms. Sealman, I need you to look up Mr. Al-Rihani's name. See if he has another gambling case in the system.
Yes, he does, Judge.
And what's the case number?
It is 230-448-2901.
So they're both from 2023?
I believe that one was from 2021 and the other was from 2022.
Oh, and then the warrants were just issued in 2023. Okay, what's his court date, or what's the status of that other case? Is it in warrant status or?
It's a non-service warrant. It's in
Okay,
warrant status.
so the other case, to answer your question, Mr. Al-Rihani, is in warrant status, a not in custody warrant, not a KPS warrant. So I could arraign your client on that case, and I guess what the people's offer is that they would agree to place Mr. Al-Rihani in diversion for that first case, and then enter a plea on this case for a delayed sentence. Is that your offer, Ms. Rankin?
That is, Your Honor.
All right. So, Ms. Sealman, is the case that you gave me, the case number 4, the charge is also gambling, disassociated person?
Yes, it is.
All right. So then with respect to case number 23448291001, the people of the state of Michigan versus Alan John Al-Rihani, defendant is charged with 1 count of gambling, disassociated person. Today isn't the date set for anything, but the court will arraign Mr. Al-Rihani as to that matter. And counsel, how would he wish to plead with respect to the first one?
At this time, my client would stand mute and waive the formal reading of the complaint, Your Honor.
Court will enter a not guilty plea. And then, so with the new case coming up, I guess what I would think is that we would adjourn the pretrial conference for the case that was on my docket today, set this second case for pretrial conference, make sure that Mr. Al-Rihani gets the diversion paperwork for the first case, and he can enter into diversion for the first case. And then someone could then tell me what the conditions are in the diversion program. Like, I've never known what the conditions are. So someone could tell me at that time what the conditions are for the diversion program. And then if he enters into a plea for the second case under a delayed sentence, I wouldn't duplicate the requirements. So it would be like he's doing diversion, but probation at the same time. Okay,
I
so
understand.
let's set a pretrial conference. How long do we think it'll take for the well, I can't give a date before September. Is that enough time? In
Plenty of time for defense counsel, Your Honor.
Ms. Rankin, is that enough time to get the paperwork out and everything?
That is, Your Honor.
All right, let's come back on a Tuesday, September the 19th.
Oh,
Is that a good day, counsel?
it's a bad day for me, Your Honor. It's my wife's birthday and I'm taking her out of town that week. Can we do either the week before or after?
She can celebrate her birthday anytime, counsel.
She'll get mad at me. She won't be happy with it.
I don't blame her. I don't blame her.
Yeah.
We can do the 26th, counsel.
Okay, that works. Thank you, Judge.
Okay, so the court will set case number 23-448-29-1001. I'll set that case. I seem like I got too many numbers. 2, 3.
Your Honor, you adding a 1, it shouldn't be a 1.
Oh, I'm adding that 1 on the end. Okay, 2901. Okay,
Yes.
thank you. All right. I will set that case for pretrial conference September the 26th. 0448291. And I will, as I indicated, enter a not guilty plea. And then I will adjourn this pretrial conference as well to September the 26th.
Is this morning docket, Your Honor?
Yes, 8:25, same docket. And then make sure that we get, you follow up, Mr. Hawana, make sure you follow up so that that diversion piece can be taken care of before we come back on the 26th, okay?
Thank you. Is there a good email for Ms. Rankin or Ms. Peterson to reach
Ms.
them at?
Peterson. As much as I respect Ms. Rankin, we email it to Ms. Peterson.
Okay, thank you.
That's what I got a feeling. Ms. Peterson, can you put your email in the chat to Mr.
Yes, I will.
Hawana?
Your Honor, are you entering a fine on this?
Both of y'all call me at the same time. Yes, don't be stressing me out because y'all trying to do something. Miss Knight texting me, you said, okay, Miss Peterson, put they all trying to come at me at the same time. Miss Peterson, put your email in the chat for Mr. Hawana. Okay, there we go. Counsel, you see it. Okay.
Yes.
With respect to the first case on that, I mean, not the first case. With respect to the second case that we found today, counsel, they texted me and stuff saying, don't forget to set a bond. So as to bond, is there anything as to bond?
No, Your Honor, my client's not a risk to the public safety or to himself. He's appeared at every court date. We just asked for a personal bond on this case.
Any objection from the people?
No objection, Your Honor.
$500 personal bond, and of course, no contact with casinos.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
You're welcome. Anything further?
Nothing further from the people.
We're all set then. Everyone have a great day. Stay safe.
Thank you, Your Honor. You too.
Thank you.
You're welcome. They left. Miss Ripley? I don't even see counsel anymore.
Yes.
Okay, Miss, and you know I forgot her name.
Miss Gray?
Yes. Miss Gray left. I know she has said she was in circuit court or something, but she's not here. Her client is still here.
She'll probably log back on, I'm sure.
Yes. So this what I'll do. You can put your phone number in the chat to the clerk, Miss Silman. You can chat her your phone number, and then we can call you when Miss Gray comes back, unless you just want to sit in the waiting room. It's up to you.
I don't mind waiting, Judge. It's just up on my computer, so I can do other
Okay.
things.
All right, I'll put you in the waiting room, and then when she comes back, I'll bring you out.
Okay. Thank you, Judge.
You're welcome. Change her name. That's great. All right, when prompted to do so, please unmute and identify yourself to the court. When prompted to do so, please unmute and identify yourself for the court. Now, y'all just unmuted. Archer, please unmute and identify yourself for the court.
Good morning, Judge Brown. I'm Mr. Chair.
Judge Brown, I'm Mr. Chair.
You have an echo. I'm not sure. And state your name for the, why y'all unmuting before I prompt you? Howes, please unmute and state your name for the court.
Devion Howe.
Devion Howe.
This is why I don't allow y'all to. Miss Moody, why do you keep unmuting yourself before I ask you to? Please stop. Can the person on the iPhone that's being prompted, please unmute and state your name for the court? This is ridiculous. Now you were unmuting when I didn't want you to unmute.
Devion House.
I'm not speaking to you, Mr. Howes. I'm prompting an individual. And it wasn't Miss Moody.
Can you home?
Okay,
It's too much. And then you're going to yell your name at me like 3 times to the person on the iPhone. Are you all, is something going on that I need to be aware of? Don't do that again.
No, my phone messed up.
Okay, well, don't scream at us though. Don't scream at me. Now you being ridiculous. It wasn't messed up when I didn't ask you to unmute, but then all of a sudden when I'm prompting you to unmute, your phone is messed up. Can you state your name, please?
Daniel Holmes.
Thank you. Now, Miss Moody, please state your name.
Tamara Moody.
Thank you. Thank you. Everyone, please start your videos now. Mr. Archer, I'm going to send you back to the waiting room while we wait for your lawyer to arrive.
Yes, ma'am.
Everyone else, please accept to join the breakout room. Do not come out of the breakout room until you have spoken with a lawyer. Mr. Howes, please join breakout room number 6. Ms. Moody, please join breakout room number 7. Mr. Holmes, please join breakout room number 8. Now she saw that, okay, ma'am. All right, I'm ready on Foster, Murphy, Ginyard, and House. This is case number 1-845-10-801, the people of the state of Michigan versus Shaquan Foster. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
Janice Stevenson appearing on behalf of Ms. Shaquan Foster. Ms. Foster, ma'am, please unmute and tell the judge your full name.
Shaquan Foster.
Thank you. Today is the date set for final pretrial conference. How are we proceeding?
Your Honor, Ms. Foster will continue her plea of not guilty and respectfully demands that this matter be set for jury trial.
Court will continue a not guilty plea. On behalf of Ms. Foster, place the matter on the jury trial track. I will set a final pretrial conference for February. February 20th, 2024. At 9:19. If you need a reminder of that court date, please go on the court's website at 36districtcourt.org and sign up for text notifications of your court date. Anything further?
No, thank you, Judge.
Nothing on behalf of Ms. Foster. Thank you, Your Honor.
All right, Ms. Foster, you're all set. Have a great day and stay safe.
You too, thank you.
You're welcome. Thank you. This is case number 22-4449801. The people of the state of Michigan versus Larry Murphy. Defendant is charged with 1 count of assault or assault and battery. Today's the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Larry Murphy. Mr. Murphy, sir, please tell the judge your full name.
Larry Murphy.
Thank you. Today's the day set for final pretrial conference. How are we proceeding?
Thank you, Your Honor. Mr. Murphy continues his plea of not guilty and demands that this matter be scheduled for jury trial.
Court will continue a not guilty plea on behalf of Mr. Murphy. I will place the matter on jury trial track, setting a final pretrial conference for February the 20th, 2024 at 9:19. If you need a notification or reminder of your court date, sir, please go onto the court's website and sign up for text notifications of your court date. Anything for the record?
No, thank you, Judge.
Nothing on behalf of Mr. Murphy. Thank you, Your Honor.
All right, Mr. Murphy, we're all set. Have a great day. Stay safe.
All right, thank you.
You're welcome. It's dark. Ms. Ginyard, you're dark. Thank you. This is case number 194503501. The people of the state of Michigan versus Lynise Ginyard. The defendant is charged with 1 count of child abuse, 4th degree. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Denise Ginyard. Ms. Ginyard, ma'am, please unmute and tell the judge your full name.
My full name is actually Jehudiah Israel. It hasn't been Denise Ginyard for over 7 to 8 months now. When I went down to 36th district.
That's too much.
Janice Stevenson appearing on behalf of Jehudiah Israel, also known as Denise Ginyard, Your Honor.
Okay, she's only known as Denise Ginyard on this record.
Understood,
I
Your
don't
Honor.
even know how to, I mean, okay. Today is the date set for an arraignment on a bench warrant. And Ms. Ginyard Capey is at a pretrial conference. In January. Ms. Stevenson.
Your Honor, as to the arraignment, Ms. Ginyard will stand mute, waives a reading of the information as to the plea of not guilty. Enter on her behalf, Your Honor. We'd ask that this matter be rescheduled for pretrial conference, that the bond posted for today's court date be continued, Your Honor. It is my understanding that Ms. Ginyard does not have custody of the child in question in this matter, Your Honor.
The court will enter a not guilty plea with respect to the arraignment on the bench warrant. Set aside any capias and recall any warrant if there be any still outstanding. I will set the matter for another pretrial conference. The court will set the pretrial conference for September the Now, let me say this while I set this case.
Okay.
So I'm glad Ms. Knight is on here. Now, Ms. Stevenson, you said something to me the other day, and you said, Judge, what happened on Friday? Why do we have such a light docket on Friday? And then I said, well, I don't know. I didn't realize we had a light docket. And then I went to my book. I went to my book where I keep track. And at some point, somebody somewhere have been giving me the wrong count for cases, which has probably made me set cases on a different day where I'm probably now overbooked. So when I looked at the docket for Friday, we only have about 12 cases. It's a whole bunch of sentencings, about 7 sentencings. In fact, all of those cases appear to be like retained or appointed cases. But in my book, I literally have that at one point, somebody told me I had 22 cases on July 21st. And at another point, somebody told me I had 28 cases on July 21st. Now, Ms. Knight, that's not acceptable. So I really only had 12 cases. And then I probably overbooked myself on another case. So nonetheless, I said that to say, let's please make sure we're looking at the correct date when I'm asking for how many cases I have on a particular day. And so, Ms. Stevenson, I think on Friday, you only have about 1 or 2 cases.
2.
Yeah. All right. So the court is going to set this matter for another pretrial conference. How many do I have on September 19th? September 19th. Because I got a big old circle around Friday, July 24th, and I put no more.
Yeah, 2, Your Honor.
How many?
2 jury trials.
I only have 2 cases on September 19th, period.
Correct. And then both says jury trials.
Court is going to set the matter for September 19th. At 8:34, failure to appear will result in the bond being increased. And a potential GPS tether being ordered. At this point, bond will continue with, nope, oh, with no contact with complaining witness. Did you give discovery yet?
Was it sent Ms. Ritter from previously?
Correct, Judge. The people sent discovery on January 10th of 2023. But if you need it again, Ms. Stevenson, you can always reach out to me.
Okay, thank you. Can I just have it? Because I know that probably, they only do 90 days when it's system generated.
Okay, I'll resend the
Thank you.
discovery, Judge.
All right. So we'll be all set for September 19th?
Yes, absolutely.
Yes,
Okay.
Judge.
All right, then we're all set until September 19th at 9:00 a.m. Let me just make this statement. The only way I'm using Ms. Ginyard's name that she says she's had for 8 years or 7 years, she has to file paperwork with the court. I can't, this legal. We're legal on here. So the complaint was issued in the name of Denise Ginyard. It does not have an AKA on it. This is from 2019. So for the purposes of court, the case is for Denise Ginyard. If she wants an AKA put on her file, then she has to present the court with appropriate paperwork as to the name change. We're all set. Have a great day and stay safe. Ms. Gray, you ready?
Yes, Your Honor, I am ready. Thank you.
No problem. Let me bring the APA in.
Okay, thank you.
Perkins. Ms. Perkins, start your video. Ms. Ripley, I'm ready. All right, this is case number 234466001, the people of the state of Michigan versus Felicia Perkins. The defendant is charged with 1 count child abuse 4th degree, 1 count of assault or assault battery. Today is the date set for a pretrial conference. Appearances, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
Good afternoon. Good morning, Your Honor. May I please the honorable court, Stina Cobra Gray, appearing on behalf of Ms. Perkins. Your Honor, I have not had an opportunity to speak with Ms. Ripley, Your Honor, but we would respectfully request, with the court's permission, to set this matter for trial.
Ms.
And
Gray,
should
you moving so fast. You moving so fast for me.
Judge, I'm sorry. I'm in court,
I
in
know.
circuit court.
No, you trying to hurry up. Ms. Perkins, just put your name on the record for me. Unmute, please. Put your name on the record. Unmute.
Felicia Perkins.
All right. So, Ms. Gray, you're indicating you want to continue the not guilty plea and you need some discovery?
Yes, Your Honor, please.
Okay. The court is going to continue a not guilty plea on behalf of Ms. Perkins. I will set the matter for final pretrial conference October the 10th, if that's a good day.
Your Honor, I have a jury trial scheduled that day. May I have the week prior or the week after at the court's, availability?
Madam Prosecutor, if I give her the week before, is that enough time? The discovery cutoff would be September 1st. Is that enough time for you to get her the discovery?
Yes, Judge, I can send her discovery. The week prior, I'm available the 5th or the 6th, if that's
Okay,
possible.
so then let's set the matter for October the 5th. And that'll
Thank
be
you, Your Honor.
You're welcome. And then the discovery will be submitted by September 1st.
Thank you. And Judge, may I give the prosecutor my email address if that's possible?
You may.
Thank you. My email address, Ms. Ripley, is Attorney Gray, ATTORNEY, Gray, GRAY, @comcast.net.
Perfect. Thank you so much.
All
Thank you,
right.
Ms. Ripley. And Judge, thank you for always having patience with Attorney Gray. I appreciate you. And you know I love you, Judge.
No
Bye-bye.
problem, Ms. Gray.
Bye-bye.
All right, bye. We're all set, Ms. Perkins, until October 5th. Have a great day. Stay safe.
You too. Bye-bye.
Bye-bye.
Thank you, Judge.
Your Honor,
All
what
right.
time? And
9
it would be
o'clock.
okay.
9 o'clock. Mr. Byrd, are you ready on, okay, what time? It's 9:30. It's 9:39. I'm gonna release, the Miltons. Who do I have in the jail, please? Can the jail unmute? And then we may need to call Mr. Toussaint. Can the jail unmute for me? Who do I have in the jail, please? Ms. Stillman, do you know who I have in the jail? Because they won't unmute. Oh, there we go.
Al-Sadie, Hisham Al-Sadie.
I'm sorry?
Hisham Al-Sadie.
Can the deputy tell me who this is? Because I can't hear him. Y'all got the camera way back there. Who is this I have?
Good morning, Judge. Hisham Al-Sadie.
Oh, okay, Hisham Al-Sadie. Okay, thank you. All right, I'm gonna send him to a breakout room so he can talk to the lawyers. All right, good morning. Oh, wait. Miss Milton isn't connected, Miss Ritter. Did you talk to her in the breakout room?
Yeah, Judge, she left and then she came back.
Okay, well, she's not connected, but Mr. Milton, good morning.
Good morning, Judge. How are you?
I'm wonderful, thank you. How are you?
I'm doing well, thank you.
Okay, so Mr. Smith has not appeared yet, and it is now 9:41. So you can continue to wait. I'm going to capious him at the conclusion of the docket, but it appears that at this point, it appears that he's capious. So I would capious him and put a warrant out his arrest. There's Ms. Smith. Ms. Smith, if you could unmute or start your camera for me. Maybe not still. Okay. So did you want to continue to wait and see if they come, or the prosecutor, if he comes before I conclude my docket, which I only have 1, 2, 3, 4, 5 cases left, 6 cases left. If he comes before I finish, we can call you if you want us to do that, or you could continue to wait. But if he doesn't appear, I'm going to issue the capious since he didn't appear last time.
Okay, yeah, I have some other things I could do in the meantime, and so I don't have to wait around.
All right, well then, if he comes, the prosecutor will call you. If not, then I'll issue the warrant for his arrest. Okay.
Okay.
All
Thank
right.
you, Judge.
You're welcome. Have a great day.
Appreciate it. Okay. You too.
Miss Stewart Milton, did you hear what I said?
Yes, I did.
Okay.
I agree with my husband.
Okay. All right, then you all set. And if he comes before my docket is over, Miss Ritter will call you.
Okay, thank you very much.
All right.
Thank you.
Okay, I'm ready on, do y'all hear? I feel like I'm losing my voice. I feel like I'm losing my voice. Oh, I was going to try to bring in Knox again. They are not. I tried to bring them in twice before, and then did you all talk to Moody? I don't have a star by Moody. Did you talk to Moody?
Ms. Moody's camera and phone actually went out. I gotta go back in the breakout room with Miss Moody.
Okay, let me try to bring her in now. And then we're ready on, and then I sent that person to the jail, Al-Sayadi. That's who's in the jail. Okay, finally, Mr. Knox connected. Can you unmute and state your name, Mr. Knox?
Robert Knox.
Thank you. Next time when you log in, be ready for court. I've been trying to get your attention all morning.
I've been sitting here with this thing on all day. It said I was waiting on you.
For real, you were sitting there with it all day. So the 3 times I brought your device.
I didn't cut it on at 8
Let me
o'clock
say
this
this,
morning.
you gonna talk over me or am I gonna talk? What's gonna happen today? So the 3 times that I brought your device in the waiting room, from the waiting room, the 3 times that I shared this screen right here because you were not connected, you're saying you were sitting at your device?
Yes.
And so what stopped you from connecting?
I never seen this.
Oh, because you weren't at your device, sir.
No, it was showing another screen. I've been on the screen.
Because you weren't at your device, sir. You were not at your device. Now, I've let 3 groups of people into this courtroom, and each time I brought your device in with them. Miss Moody, please unmute and state your name.
Tamara Moody.
Miss Moody, haven't you been in the breakout room?
Yes, ma'am.
Didn't you come into the courtroom and I shared that screen that I just shared?
Yes, ma'am.
And didn't you start your device and everything?
Yes, ma'am.
Oh, I was just checking. Mr. Knox is acting like I didn't know what I was talking about. I was just checking, Miss Moody. Thank you for,
You're welcome.
You can start your camera. Mr. Knox, start your camera. Because you were in the same, you came in the same time Miss Moody came in. Start your camera. Yep, okay. Miss Moody saw the screen share. You didn't see it because you were not at your device. I'm going to send you both to the breakout room. Please accept to join the breakout room. Miss Moody, you've heard this before. The lawyer will come in and speak with you.
Yes, ma'am.
And Mr. Knox, please accept to join the breakout room and wait for the lawyer to come in to speak with you. All right. I'm going to do Smith House, and then it looks like Mr. Toussaint has joined us. So what happened to Mr. Houston and his client? Are they still in the breakout room? They are not. What happened to Mr. Houston and his client? They are not in the breakout room. Am I missing Mr. Houston? His client is in the breakout room, but Mr. Houston isn't in the breakout room. Did I put Mr. Houston in the wrong breakout room? I did not. Okay, that's interesting. All right. Okay. I'm ready on Smith. Are you ready on Smith? You're muted, Mr. Bird.
Ready on Smith, Your Honor.
Okay. And then by any chance, are you ready on Johnson? That the Johnson is in person. Are you ready on Johnson maybe, or no? It's a first time pretrial.
I would have to talk to Ms. Stevenson about that, Your Honor.
Okay. Well, let's go ahead and do Smith. And then look at Mr. Knox back in the waiting room. You see what I'm saying? Okay. All right, I'm ready. Oh. Let's try again, Mr. Knox. Let's try again.
Okay.
I'm next.
All right, I'm ready on Smith. Let me put Moody in the waiting room. This is case number 234467601, the people of the state of Michigan versus Adina Denise Smith. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pre-trial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Yes, Your Honor, we please this honorable court, Brandon Byrd on behalf of Dina Smith, PA 3734. Please state your name for the record, Ms. Smith, your full name.
Adina Denise Smith.
Thank you, ma'am. Today is the date set for a pretrial conference. Mr. Byrd, how are we proceeding?
Respectfully, we're going to ask this court for dismissal if the complaining witness isn't here.
Ms. Ritter.
Judge, it's the first scheduling of the pretrial conference. I respectfully request the court to adjourn the pretrial conference to give the complaining witness one more opportunity to appear.
Today is the day set for pretrial conference. The court is going to deny defense counsel's motion for dismissal. I will grant the people's request for a one-time adjournment, giving them an opportunity to notify the complaining witness of the obligation that they appear before the court. I am going to set the pretrial conference for, how many do I have on August the 30th? Wednesday, August the 30th.
Judge.
Thank you. The court is going to set the matter for August the 30th. At 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complainant could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Judge.
Nothing further, Your Honor. Thank you.
All right, Ms. Smith, you're all set until August the 30th at 8:36, ma'am. Have a great day and stay safe.
Thank you. You as well. Thank you.
Mr. Houston, did you need to go back in the breakout room with your client? You're muted.
No, I'm okay. I got kicked off somehow, so I just logged back in, but we're all ready to go.
Okay. Mr. Howes, please start your video. Thank you. This is case number 234412101, the people of the state of Michigan versus Davion Howes. The defendant is charged with one count of assault or assault and battery. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Mr. Byrd?
I apologize, Your Honor. I thought we were doing a
No, this Mr. Howes, this is MFD.
I apologize, Your Honor.
You're not ready on Howes?
I should be, Your Honor. What?
Mr. Howes is at 9 o'clock, final pretrial conference.
Yes, Your Honor. Brandon Byrd. I'm trying to get the first. Oh my God. Yes, Your Honor. Brandon Byrd on behalf of Davion Howes. Mr. Howes, please state your full name for the record.
Davion Jamil Howes.
Thank you. Today is the day set for a final pretrial conference. How are we proceeding?
Your Honor, respectfully, we're going to ask this case for dismissal if the complaining witness isn't here.
Ms. Ritter, was the complainant required to appear today?
The complainant was not required to appear today, Judge. Actually, the complaining witness is a minor, so the court did not require his appearance.
Oh, the complaining witness is a minor? Thank you.
Yes, Judge. You're welcome.
All right, Mr. Byrd.
And we'd like to set this for a jury trial, Your Honor.
The court will continue a not guilty plea on behalf of Mr. Howes. And due to the nature of the case, the court is going to go ahead and set a jury trial in the matter. Court will set a jury trial for shame. All right, I have 2 jury trials scheduled on January 16th. I have Ayers, which is MFD. And I also have Booker, which is MFD. I'm gonna add House. And I'm gonna make House the priority case. Just stay muted, just stay muted. When is the final pretrial conference for Booker? The final pretrial conference for Ayers is September the 6th. Can you look at that January 16th? And tell me when the final pretrial conference is for Booker?
Now you say January 16th, Judge?
January 16th, there's a jury trial for Booker. Can you tell me when their final pretrial conference is?
Your Honor, I do not see a Booker for January the 16th. I see Ayers, but no Booker. Do you have the case number?
Ms. Ritter, do you have your calendar?
I do, Judge.
Do you know the name of the case on the 16th other than the last name?
On January 16th?
Yes.
I don't have that on my calendar, Judge.
Ready? Anything further, I'm going to set Mr. House a final pretrial conference for December the 21st at 9:10.
Nothing further from the people, Judge.
Anything, Mr. Byrd?
Nothing further, Your Honor.
All right. And that jury trial, of course, is at 10:30. Final pretrial conference is at 9:10 on Zoom.
And what date is that, Judge? September?
I didn't say September anything.
Oh, sorry. Okay, I got the final pretrial date. I just didn't get the jury trial date. So what's the date? I'm sorry.
January 16th.
January 16th. All right.
Mr. House, you're all set, sir. Have a great day. Stay safe.
You too. Thank you.
Good morning, Mr. Toussaint. No, okay. I'm ready on move. No, I'm ready. Oh, I have to bring your client out of the breakout room. Mr. Toussaint, good morning.
Morning, Your Honor.
You ready on
Archer.
Archer?
Yes, I am.
All right, I'm going to take Archer and then Lumpkin. This is case number 214552101, the people of the state of Michigan versus Terry James Archer. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Judge, may it please this most honorable court, Vincent J. Toussaint, P58609, on behalf of Mr. Terry Archer, who today appears by Zoom and consents to having this hearing heard by Zoom today.
Mr. Archer, please unmute and state your name.
Good morning, Judge Bryant. My name is Terry James Archer.
Thank you. Today is the date set for final pretrial conference. Mr. Toussaint, how are we proceeding?
I believe at the last proceeding, Your Honor, you have requested that Ms. Ritter have the complaint here to see if they want to still go forward.
Mr. Ritter.
Your Honor, that is correct. So the court did set this final pretrial conference and required the complaining witness to be present, Your Honor. At this time, I don't see the complaining witness, Mr. Victor Murray, in the waiting room, Judge, and I don't have an explanation as to why Mr. Murray is not present. I do understand there's an unidentified device in the courtroom right now, and in the event that is not the complaining witness, Judge, the people will not be able to proceed based on the complaining witness's failure to appear for today's final pretrial conference as ordered by the court.
Can the individual that I just let into the courtroom please unmute and state your name? And state your name. All right. I don't know who that is on the iPhone. They are unmuted, but they are not stating their name.
And Your Honor, based upon the reputation.
Daniel Holmes.
You gonna keep doing this, Mr. Holmes?
No, I had myself on mute.
Come in person, because I'm not going to keep doing this with you. I promise you that I am not. Mr. Holmes, I promise you that I am not. You need to come in.
Myself was on mute. My bad.
Yeah, my bad too. It's my bad too. I'm not going to keep doing this with you.
Okay.
Didn't I already say that the only way I was going to hear Mr. Holmes was in person? Y'all sending me something, but that's not for me. So.
Oh, I'm sorry, Judge.
They keep unmuting me.
No, I keep muting you because you are disrupting my court proceedings. With respect to Ms. Archer, today is the day set for final pretrial conference. The complaining witness was required to appear. They have failed to appear. The people have no explanation for the failure, and they are unable to proceed without the complaining witness's cooperation. The court is therefore going to grant defense counsel's motion and dismiss the matter without prejudice for failure of the complaining witness to appear. Mr. Toussaint, are you able to send over the order of dismissal to my clerk today?
I am, Your Honor.
All right. Ms. Archer, we will mail you a copy of the, what happened to Ms. Archer?
I'm here, ma'am.
Mr. Archer, where? Oh, there you go. You over there in the corner, Mr. Archer, I'm sorry. It's just because, you know, the stuff moving around, Mr.
I understand.
Okay. Mr. Archer, we will, your lawyer will get you a copy for your records, okay?
Yes, Judge Bryant. Appreciate you. Thank you so much, ma'am.
No problem. Have a great day. Stay safe, Mr. Toussaint. Of course, you know it's great to see you.
Okay.
Always good to see you. Thank you very much, Your Honor. Thank you, Mr. Archer.
Yes, sir. Thank you. Talk to you later.
All
All
right.
right, take care.
Ms. Stevenson, do you all need to speak to Mr. Holmes again in the breakout room?
Yes, I do, please, Your
I
Honor.
know you do. And let me say this, if he get disconnected again, it's only one way that I'm going to see Mr. Holmes' case.
Yes, Your Honor.
Mr. Holmes, accept to join the breakout room and wait for Ms. Stevenson to come in to speak with you.
Okay.
I'm ready on Lumpkin. This is case number 194624301, the people of the state of Michigan versus Marsha Lumpkin. The defendant is charged with 1 count of child abuse, leaving a child unattended in a vehicle. And today is the date set for sentencing. Appearances, please.
For the record,
Good
Your
morning,
Honor.
Your Honor. I'm sorry, go ahead.
Mr.
For the
Houston.
record, Your Honor, Christina Ritter on behalf of the people.
And Daryl Houston on behalf of Mrs. Marsha Lumpkin. Mrs. Lumpkin, can you please state your name for the record?
Marsha Lumpkin.
Thank you. Today's the date set for pretrial conference. Did Mr. Holmes go to the breakout room?
No, nobody
Your
ain't
Honor,
sent me to.
Oh,
when you send Mr. Holmes to the breakout room, I got the invite instead of him.
Oh, okay, thank you. Okay, because I was getting ready to make him come in person. Thank you, Mr. Houston. Thank you.
Welcome.
Okay. It's the DH. I just probably saw D and H. You see, you're not on a good
Yeah.
thing today. You got, your name was too close to Mr. Holmes. All right. With respect to the pre-sentence report, are there any additions, deletions, or corrections on behalf of the people?
No, Your Honor.
You're not the people no more, Mr. Houston.
I'm sorry.
Look, you got the people anymore. On behalf of the people, Ms. Ritter.
The people had an opportunity to review the pre-sentence report. I don't see any additions, deletions, or corrections on behalf of the people.
All right, on behalf of the defendant.
Your Honor, I was able to go over the pre-sentence report with Mrs. Lumpkin. I did have a couple clarifications and questions about it. On the page 2 of the report where she lists the different recommendations, she had the box checked to attend a parenting program, which we have no objection to. However, on page, I believe that's page 9 of the report, where it's more detailed evaluation and plan, there's an additional recommendation of the complete the choices program. And my question is the choices program and the parenting program one and the same? I was able to go on the choices website, and they do, it seems like they do offer those parenting program and services. So I just wanted to clarify, are the parenting program and the choices program the same, one and the same recommendation?
I can get to that at the point of sentencing.
Okay.
And the short answer to your question is no.
Okay.
All right. Anything further with respect to additions, deletions, or corrections?
Nope, nothing further in respect to those.
All right, and then anything, Ms. Ritter, on behalf of the people for sentencing?
So, Your Honor, the people did look over the recommendations from probation. I believe that the probation period for 1 year is acceptable in this matter, Your Honor. I see that Ms. Lumpkin does not have any prior criminal histories. And I asked the court to adopt the recommendation from probation at this time. If the court does see that the Choices program is a better fit opposed to the parenting program, the people have no objection to that change, Your Honor.
Mr. Houston, anything further with respect to sentencing?
Yes, a couple of things, Your Honor. If the court requires Mrs. Lumpkin to do a separate program in addition to the Choices program, would the court be amenable to striking the 40 hours of community service just because Mrs. Lumpkin is a stay-at-home mother and has 4 children? If the court is not amenable to striking the 40 hours of community service, will the court allow her to do the community service in Lansing? Her and her husband, her family are in the process of relocating to Lansing to be closer to her husband's place of employment. So that's something we're asking the court for. And then lastly, would the court also be open to delayed sentencing in this matter, given if she completes the probationary period successfully, having this matter dismissed to preserve her record in cases for future employment opportunities, and given that she does not have a criminal record and has had no other contacts with the criminal justice system since this date of offense.
Would Ms. Lumpkin might like to make any statement on her own behalf?
I'm sorry, go ahead.
Yeah, if you want to address the court, you can. It's totally up to you.
Okay. No, I just wanted to take the time just to say thank you for every just the opportunity just to say something. I appreciate the time that everybody took out for this. I definitely do regret the choice that I made, but I'm grateful for just the support and love of family and friends, and just in the time that everything has happened. So thank you to the judge and to Mr. Houston.
All right. Okay, so the court has had an opportunity to review the pre-sentence report, and I'm ready to impose sentence. Oh, I apologize, Ms. Ritter. Mr. Houston asked me about a delayed sentence, which of course, I'm always amenable to. Did the people have an objection to a delayed sentence for this case?
Your Honor, at this time, the people don't have an objection. As stated, there's no prior criminal history, so of course I will leave it in the court's discretion as to the delayed sentence in this matter.
All right, so the court would sentence Ms. Lumpkin pursuant to MCLA 771.1 delayed sentence for 12 months as recommended by probation. I was a little, I don't know, disheartened, I guess. And I mean, I know that it continues to happen, but I don't know why. When I read her statement on page 4, so I'm saying this really to address your question, Mr. Houston, about choices. So I think this would be a great, this is like the very kind of thing Choices program might need to address. It's totally different from parenting classes. So parenting classes, they teach you certain things. I don't really know what they teach in parenting classes. I just know a lot of people who don't have any criminal cases need to sign up for some parenting classes. And but so parenting classes, that's something totally different. But Choices, it is designed to help people think about the choices that they make. And when I'm looking at her statement on page 4, and she was saying that she, her husband was out of town, blah, blah, blah. And she had to go pick up the kids from school, da, 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 da. She was only planning to be in the store for a minute. And then one of the kids usually cried when they were in the store. And then they were asleep, so she left them in the car. And I remember when my children were small and I used to have food with them, but my children were far enough apart where, by the time I had my second child, my first child could help me and push the stroller and whatnot. And there was never a day, a minute, a second, an hour that I would ever think of leaving my children in the car for any reason. And especially as things have developed and we know that children and pets can die quick in a car. So I don't care if the child is screaming loud in the store. First of all, that's why I tell people, I don't get embarrassed. Now, the other day, my daughter was trying to tell me that just because a person is not embarrassed by something, like she was trying to tell me how it's still embarrassing. And I was like, no, if I'm not embarrassed by it, it's not embarrassing. Like I'm not embarrassed. So I wouldn't care if my child was screaming in the store. Now, if the people gonna be irritated because we're insensitive human beings. A lot of people are just insensitive human beings. And so, we'll be in the store and then somebody be like, can she stop that child from crying? No, I can't. And I'm in here getting my groceries. But my child is safe in here because those same people who looking at you sideways and crooked with an attitude and they face tuned up about your kids are the same ones that when they go outside, they're going to call you a horrible person for leaving the kids in the car. So choices and hindsight is 20/20, and maybe she's already learned her lesson. But I am going to order the choices and the parenting classes. Now, what I will probably not order is the community service. But I am going to order the choices and the parenting classes because those two are both important and they go hand in hand with the charge. There's never a good situation. The only time that I would ever consider leaving my children in a car, let's say I'm going up to somebody's house to pick up something that they have for me. And I pull up in the driveway and the person is coming to the door. Like I ain't gonna take all my kids out just to go up to the porch to get the thing because I'm right here. But if I was gonna go inside of that person's house to talk to them, my kids gotta come. I can't leave them in the car. So that's the place that we have to get in. Kids are not an inconvenience. Children are a responsibility. And once we have them, it's our responsibility. So whether I'm running in the store real quick, if my children are of a certain age, we all have to run in the store real quick. It's not an inconvenience, it's a responsibility. If I have to have 5 kids in a buggy, I need to remember it's not an inconvenience, it's a responsibility. And all the mean people that's in the store that want you to get your kids and they saying your kids bad, you could care less about those people. You're trying to keep your children safe. And so that's the thing that I didn't like about what I read. So the court is going to set the probationary period at 12 months. That gives a final review date of July the 18th. Wait, today is the 18th? Yes. July 17th of 2024. That's the final review date, July 17th. However, you are eligible for early discharge after 6 months. The 6-month date is January, I think, 1, 2, 3, 4, 5, 6, yes. January the 18th. So I'm going to set your review date for January 18th, 2024 at 10 o'clock a.m. And then if you don't finish the probation by January 18th, there's no penalty. That's just the halfway point. That's the reward if you finish early. If you don't finish, then you will just continue you. The court is going to impose the following fines, costs, and fees. Of course, the mandatory costs Ms. Stevenson, while you're sitting waiting for me to finish this sentencing, can you look in your paperwork and see if you have a jury trial that everybody telling me I wrote in my book wrong. January 16th, I had a jury trial for MFD for the last name Ayers and then the last name Booker. Nobody seems to have Booker in their paperwork while you're waiting for me. I don't know the first name because I only write last names.
Did you say 121, Your Honor?
No, I said 116.
116. Okay, yes, Your Honor.
Okay, thank you. All right. So the court is going to impose the mandatory cost of $210. And then Mr. Houston, I'm looking at page 4 and I'm looking at her source of income and it only says the public assistance, but you say she's married to a man with a husband with a job in Lansing. Why? I don't know why they wouldn't list that as her other income, but does she want? So I said I wasn't going to order community service as just an additional condition, but if she's not able to pay the fines, costs, and fees, she has to pay the mandatory. If she's not able to pay the fines, costs, and fees, she needs to do community service in place of the additional fines, costs, and fees. But it doesn't list her spouse's income on here as an additional source of income. So I can tell you how much it would be, and then you all could tell me if she wants to pay it or do community service. So the court would impose a $300 fine, no restitution, supervision fees at $35 per month for a total of $420 and a $35 assessment fee. So the total fines, costs, and fees would be $965 if she was finished by the halfway point. Then the fines, costs, and fees would only be $755 because the oversight fees would be reduced. She has to pay the $210, but everything else could be converted to community service. Ms. Lumpkin, what's your pleasure?
We can pay the fee.
All right, so the court is going to impose those fines, costs, and fees: $300 fine, $420 supervision, $35 assessment, $210 cost. And then, Mr. Houston, you're retained or appointed? I'm sorry.
Retained, Your Honor.
Okay, thank you. So no attorney's fee. All right, then the following conditions apply. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent of the court. You must make a truthful report to probation on a monthly basis, or as often, strike that, on a monthly basis. And you must notify probation immediately of any change of your address, phone number, or employment status. You must not use any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. That's marijuana in any form: eating, drinking, smoking, vaping, any marijuana in any form. You shall not use or possess any opiate without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid license. According to the report, your license is valid. You shall there was a recommendation that I saw. Let me just double check, make sure I'm not seeing anything. For the mental health evaluation. Does anybody have a position strongly one way or the other with that, with respect to the mental health evaluation?
Your Honor, we leave it into the court's discretion.
Ms. Ritter?
Judge, I saw that recommendation. The people will leave that in the court's discretion as well.
All right, I'm not going to order the mental health evaluation. I am going to order, as I indicated, that she attend parenting classes. I don't see that on my sheet, but I'm gonna write it. All right. And I believe through eVay, the parenting classes are 12 sessions. I want her to do it through eVay. And then they also have the Choices program. So she's gonna do 2 programs through eVay, parenting and Choices. It is my belief and understanding that those classes are on virtual, that they're not in person. So her moving to Lansing should not have any impact on her attending the Choices program. She shall pay any outstanding tickets with 36 District Court, but according to the report, she doesn't have any. There's a $65 balance, but that might be attached to this case.
Right, Your Honor.
All right, and then additionally, there was a recommendation about alcohol, but I'm not going to order that either. So in other words, she can consume alcohol. All right. Those are the court's conditions. I will see you on January the 18th for your review. If you have completed those conditions, then you will be discharged from probation. The court is going to mail this order to the Rosemont address. If you move, you need to make sure that we have your updated address. So if you move, that's the only address we have. And so you need to make sure probation is immediately notified of the update in your address. And then probation will call you at the phone number ending in 9842. Anything further with respect to Ms. Lumpkin?
Not from the people, Judge.
Just one thing, Your Honor. Does she work with probation to sign up for the Choices and the parenting classes, or does she have to sign up on her own?
No, she'll work with probation. They'll give her the referral to Mr. Rice's eVay class. And then if for some reason there is any type of conflict with the dates, they'll work that out. So she'll go through probation.
Okay, thank you, Your Honor. That's all we have.
Okay, then we're all set. Ms. Lumpkin, just keep holding your babies and making sure that your first priority is always their safety. We don't care what people think about them crying and stuff. Okay?
Yes, ma'am. Thank you, Your Honor.
You're welcome. Have a great day. Stay safe.
Thank you. You too, Your Honor.
All right. Thank you. All right. I'm ready on Mr. Al-Sayadi. This is case, all right, case numbers, plural, 21-442-7101. People of the state of Michigan versus Hisham Ahmed Al-Sayadi. Defendant is charged with 1 count of breaking and entering without owner's permission. Defendant also has case number 23-446-7001. And in that case, the defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference as to each matter. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, and with respect to case number ending in 677, I have the complainant witness present in the courtroom this morning. Sir, can you state your name for the record, please?
Yes, ma'am. William Estes.
Yes, Your Honor. Brandon Bird on behalf of Hisham El-Sadi. Mr. El-Sadi, please state your full name for the record.
Oh, I need the jail to unmute, please. Can the jail unmute? All right, the jail isn't unmuting. Mr. Al-Sadi, is your name, I might be pronouncing it wrong, but is your name Hisham Ahmed Al-Sadi? If it is, shake your head up and down. Okay. All right. Thank you, sir. Today is the date set for pretrial conference as to each matter. Mr. Bird, how are we proceeding?
Pertaining to the case ending in 271, we're going to respectfully ask this case for dismissal due to the lack of a complaining witness. And we'd like to set the case ending in 677 for a final pretrial.
The court is going to deny your request. Oh, I'm sorry, Ms. Ritter, what's the situation with the complaining witness?
So with respect to case ended in 271, Your Honor, it's the first scheduling of the pretrial conference. I don't see the complaining witness in the waiting room, and I have not noticed that the complaining witness is in court. So I'm going to respectfully request the court to adjourn the pretrial conference for case ended in 271 and give the complaining witness one more opportunity to appear before the court.
All right, the court is going to deny defense counsel's motion for dismissal with respect to the case ended in 271. I will grant the people's request for an adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I'm going to set both matters for an adjourned pretrial conference. So I do understand that the complaining witness already appeared on the case ending in 677. So, but I want to keep the two cases together. So I'm going to adjourn both pretrial conferences. And I will adjourn those pretrial conferences to, this is, let's do, that's September. Well, how many do I have on September 8th?
Uh, 17, 18, 23.
Court is going to set the matters for Friday, September the 8th. And with respect to the case ending in 677, complaining witness is required to appear. I'm going to set the matters for 8:36. So I'm setting them both for 8:36, but the complaining witness is only required to appear on the case ending in, oh wait, I'm sorry. I said that wrong. On the case ending in 271, the complaining witness is required to appear, the B&E case. On 271. Okay. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue on that case with no contact with the complaining witness unless unless defense wants to address bond in a minute. With respect to the case ending in 677, the complaining witness has appeared today. Therefore, sir, you are not required to appear on September the 8th. However, you may appear if you want to, because as the complaining witness, you may appear at all scheduled court appearances. If you do appear, as you can see, we're on Zoom. Unless there's testimony to be taken, the matters will be on Zoom. You can appear via Zoom or you can appear in person. If you're not able to Zoom in, you can always come in person. Or if you simply want to see what's going on, you can watch on YouTube if you want to. But if you don't appear on September 8th, you should contact the prosecutor's office or the victim's advocate, find out what the next court date is and whether or not your appearance is required. Okay?
Yes, Your Honor.
All right. Anything further for the court with respect to this case? I'm assuming Mr. Al-Asadi is not being held for my cases.
Correct, Your Honor.
Okay. All right. Then Mr. Al-Asadi, we're all set.
I need him back in breakout, Judge, please.
Oh, you do?
Yes,
Okay.
please.
All right. You're all set with me, sir. Have a great day despite where you are. And please stay safe. And I'm going to send you back to the breakout room. The lawyer wants to talk to you again. All right. I sent him to number 3. And sir, yes, you're all set. Thank you. Okay, Ms. Stevenson, are you ready on Johnson and Green?
Ready on, yes,
Well,
ready on
Johnson,
Johnson
Moody,
and Green.
Where's
Yes.
Moody? Where's Moody on the docket?
Under 8:30, Judge.
Oh, there, okay, yes. All right, let's do Moody. And, let's do Johnson. Let's do Johnson. And then Moody. And then it looks like Holmes and Knox are gone. Yeah, okay. Don't worry, it's all good. Listen, that happens. And the people, just have to post the bond. All right, I'm ready on Johnson. This is case number 234467801. The people of the state of Michigan versus Crystal. Looks like middle name might be Catherine, last name Johnson. Defendant is charged with, hold on, did I, let me make sure. Do I have it right, Johnson? Because I just noticed. Okay, yes. All right. Defendant is charged with 1 count of assault aggravated. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Crystal Johnson. Ms. Johnson, please state your full name for the record.
Crystal Catherine Johnson.
Thank you. Today is the date set for pretrial conference. Mr. Bird, how are you proceeding?
We respectfully ask this court for dismissal if the complaining witness isn't here.
Ms. Ritter.
Your Honor, it's the first scheduling of the pretrial conference. I'm going to ask the court to adjourn the pretrial conference to give the complaining witness one more opportunity to appear before the court.
And the person that's on the telephone without a video, unmute and state your name.
Hello? Hello?
Stop saying hello and state your name, please.
Robert Knox.
Mr. Knox, you were on video. Why did you get on the telephone without a video?
Because it kept kicking me off, and I just it said if I had technical difficulties to call.
Yeah, I don't know why they put that up here, but you can't attend court on a telephone. You need to come to court. I'll send you back to talk to the lawyer, but you can't come to court on the telephone.
I already talked to the lawyer. She had sent me out the break.
Are you listening to me, Mr. Rayleigh? Are you listening to me? Are you listening to me? Yes. You cannot attend court on a telephone without a video. I'm going to send you back to the breakout room and the lawyer will come in to speak with you again, okay?
Okay.
All right, as to Ms. Johnson, today is the date set for pretrial conference. The court is going to deny defense counsel's motion for dismissal. I will grant the people's request for a one-time adjournment, giving them an opportunity to notify the complaining witness of the obligation that they appear before the court. I am going to set the pretrial conference for August 30th. At 8:36, the complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complainant could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
Judge, does the court's position change if the complaining witness is the son of the defendant?
It does.
Because according to the investigator's report, Your Honor, it looks like the complaining witness is the son of Ms. Johnson.
And when you say the son of, though, you mean the adult son of?
Yes, Your Honor, sorry.
Court is going to continue the not guilty plea. I'm still denying the motion. Court is going to transfer the case to Judge Austin Garrett. Ms. Silman, can you call Judge Garrett's courtroom and get a date for me?
Yes, Judge.
Court is going to transfer the case to Judge Austin Garrett. Ms. Johnson, you have appeared in person. If you plan to appear in person on the next date that I'm going to give you, Judge Austin Garrett's courtroom is directly next door to mine. It's on the same floor. It's directly next door. If you're going to log in on Zoom, his courtroom number is 338. So the Zoom ID would be 360-338 and then 4 zeros. Or you could just go onto the court's website and click on his name. But I am transferring the case to the domestic violence docket.
August the 3rd, Your Honor, I'm sorry for interrupting. They said August the 3rd at 8:30.
All right. So, ma'am, it's going to be August 3rd at 8:30. And the complaining witness is required to appear. I believe Judge Garrett has the same practice as I do. However, I will let you know that his docket is being handled currently by Judge Baltimore. And I don't know what Judge Baltimore's practice is. So he may do the same thing that Judge Garrett would do, but he's not required to. So I don't know what his practice is, but they will let you know. If your son doesn't appear at the next proceeding, then they'll let you know if it's going to be dismissed, okay?
Thank you, ma'am.
You're welcome. Anything further with respect to Ms. Johnson?
No, thank you, Judge.
Nothing further, Your Honor. Thank you.
All right then, Ms. Johnson, you're all set, ma'am. Have a great day. Stay safe.
You too.
Thank you. I'm ready on Moody, please. Start your video. Oh, hold on, you can't. Let me change. All right. Start your video. This is case number 154544801. The people of the state of Michigan versus Tamara Moody. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Tamara Moody. Ms. Moody, please state your full name for the record.
Tamara Moody.
Today is the date set for pretrial conference. How are we proceeding?
Respectfully, we're going to ask this court for dismissal if the complaining witness isn't here, Your Honor.
Ms. Ritter.
Judge, it's the first scheduling of the pretrial conference, and this case is from 2015. So I respectfully request the court to adjourn the pretrial conference, just to give the people an opportunity to locate the witness and have them properly appear before this court.
Today is the date set for pretrial conference. The court is going to deny defense counsel's motion for dismissal. I will grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of their obligation to appear before this court. I am adjourning this pretrial conference to August 30th at 8:36.
Judge, I can no longer hear you, if you can hear me.
I can hear you and everybody else can hear me. Can you all hear me?
Yes, Your Honor.
It's your system. Can you hear me, Ms. Moody?
Yes, I can hear you now.
Okay. All right. So what's the last thing you heard me say?
When you were about to say that it was denied dismissal, and then everything after that I didn't hear.
Okay, so the court denied the defense counsel's motion to dismiss, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I have adjourned the case till August the 30th at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or why they should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Judge.
Nothing further, Your Honor.
Ms. Moody, you're all set until August 30th at 8:36. Ma'am, have a great day. Stay safe.
Thank you, you as well.
Thank you. Are we ready on Barnes and Green?
Ready on Barnes and Green, Your Honor.
All right. And then can somebody go back in and tell Mr. Knox why he can't come to court on the telephone? And he already is at 9:05, so he should have came down to the court. But since Friday it seems like it's real light, he can come on Friday down to the court.
Can Mr. Holmes come that day also? Judge?
Yes, yes.
Okay.
I'm ready on Barnes. I mean, I said light, but it's like 10 sentencings over here that day, and I don't know.
Excuse me, Your Honor.
That. Yes.
Barnes, step to the restroom.
All right, I'm ready on Green. This is case number 194444501. The people of the state of Michigan versus Nicole Green. Defendant is charged with failing to report an accident. Okay. And then count two, well, that count. And then count three, driving while license suspended, revoked, denied. Today is the date set for sentencing, and count two should have been dismissed. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Nicole Green. Good morning, Ms. Green. Please tell Judge your full name.
Somebody just said on my front row. Who is that?
Complaining, Michael Reeves, Your Honor.
I apologize, Judge. The people are aware that the complainant witness, I'm sorry, Judge.
Go ahead.
The people are aware that the complainant witness is in court in person. I don't know if the court will want, Mr. Reeves, can you stand up where you are and state your name for the court?
Michael E. Reeves.
All right, thank you. Okay, today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
Judge, looking at the pre-sentence report, I don't see any additions, deletions, or corrections on our end.
Oh, I remember this case. Why is it that I thought I already sentenced this case and that, why did I think I already sentenced this case and it was supposed to be some restitution about standing in the thing and Mr. Reeves already addressed the court? I'm confused. And remember he said he was coming and I said, so what did I do it? Did I do a trial? I didn't do a trial.
No, a
What
plea.
happened at the last court proceeding that I would have heard from Mr. Reeves?
So, oh, I'm sorry. Go ahead, Ms. Ritter, because you may it may be a little bit more clear coming from you.
So, Your Honor, I believe the last hearing we had was a sentencing, and Mr. Reeves did address the court. However, the court adjourned the sentencing because Mr. Reeves had some documentation for restitution, and the court wanted the people to go through that documentation to verify the restitution in this matter.
And I adjourned the sentencing?
That's what I remember, Judge. If Ms. Stevens said you have additional information, that's all I remember.
That's my recollection.
Oh, okay. So I did not sentence Ms. Green.
Right.
Okay. Okay, because this was because I remember this. So that's interesting. Okay. So then with respect to sentencing, the court has had an opportunity to review the pre-sentence report. With respect to the report, well, did we go through that part already? Additions, deletions, or corrections?
Yes.
Yes.
Yeah, okay, I knew this was real familiar to me. Okay, so we already did additions, deletions, or corrections. And then on behalf of the people, then, is there anything with respect to sentencing? Now, I already heard from Mr. Reeves, because I already know that and remember, I gave a whole big speech and I said, looks sound like it should have been charged a different way and blah, blah, blah. I remember all of that. So Ms. Ritter, anything additional on behalf of the people?
Judge, just as far as the restitution in this matter, so I did receive, there was a folder left in the court the last time for her the sentencing, and Mr. Reeves left a folder regarding some restitution information. I did receive that folder, and from the information that I have, Judge, there are some payments as far as the medical expenses that the people just had further questions regarding Mr. Reeves' out-of-pocket expenses.
Okay, well, let me ask this. Was any of the information shared with defense in terms of what may be valid claims under the Crime Victims' Rights Act in terms of restitution? Is Ms. Stevenson aware of any proposed amount for restitution?
So, Your Honor, the folder was left in the court for me. I don't know if Ms. Stevenson got a copy, but I did not send a copy to
you. Wouldn't
She
have
did
got
not. Okay, so the people did not share the information, or at least send the copies to Ms. Stevenson regarding the medical expenses and other claims for restitution.
And when you say you have more questions for Mr. Reeves regarding the medical expenses, you're indicating the questions that I would have in terms of this is what it was, but what was actually paid by insurance and then the out-of-pocket?
Correct, Judge. So the medical report that I have, it's a detailed report. However, the way it's itemized, it's unclear as to if insurance paid it's listed as expected insurance payment. I don't know if insurance actually paid it because it's listed as expected to be paid by insurance, or if it was not, because it's not clear as to if they paid the expected payment.
Okay. And then with respect to, do you have multiple bills or multiple bills that are the same, or?
So the way that the report is detailed, Your Honor, it looks like the payments range from a date starting at January 16th, 2020. That's the first visit. And then the last visit is March 4th of 2022. So they have those payments for those dates itemized in this report.
You said January 16th or 18th?
I have January 16th, 2020.
Oh, 2020. Okay, that confuses me.
And that's where the people are unclear, Judge.
Okay, so do we agree that the incident occurred on January 18th, 2019?
Yes.
Okay. Okay. Do you have any medical bills or any bills submitted with the date of treatment in 2019?
So the only date I see listed in 2019 on this report predates the incident date, Judge. So the date I see for 2019 is November 7th, 2019.
That wouldn't predate it. I mean, the incident was in January 2000.
I'm sorry, you're right. Yeah, so
So the first date that you have is in November 2019?
yes.
What are you saying? I thought he got, what? Okay. Do I have the cases mixed up or no?
No.
Okay. All right, so you don't have any medical records or claims for restitution from within a week of January 18th of 2019.
Good. I'm going through it one more time. I don't see any dates around January 18th of 2019. The date that starts on this report says November 7th, 2019. And then it ends at May 6th of 2022. That's what was included as far as the medical expenses in this folder.
Okay. Ms. Stevenson, anything on behalf of the defense? I apologize, Ms. Ritter. Was there anything else on behalf of the people?
Judge, just again for restitution, there are rehabilitation statements for physical therapy, I believe. Oh no, rehabilitation physician statements. And those statements start at February 10th, 2021. And then they end at November 21 of 2022 with the amount listed. It looks like just a screenshot of the statement dates and statement numbers and description of the statements, which is the copy that I have. And then the last document that I have is the motor scooter that was purchased online. And it looks like it doesn't give a date when it was purchased, but I see the delivery date was February 8th of 2023.
Anything further?
Not from the people, Judge.
Ms. Stevenson, anything on behalf of the defense with respect to sentencing?
Your Honor, we did at our last hearing have an opportunity to ask the court to adopt the probation department's sentencing recommendation, in that the information I have is that they did a pretty thorough interview and investigation with Ms. Green, and accordingly fashioned a sentencing recommendation. And, I haven't seen, I definitely trust what Ms. Ritter is saying to me, Your Honor, or saying to the court, but haven't seen anything to substantiate any request for restitution for out-of-pocket medical expenses that Mr. Reeves would have incurred. I have a couple of issues. I know that, we would really just have some concerns about the timeline, and whether or not any medical treatment is contemporaneous with any injuries that Mr. Greenwood, that Mr. Reeves would have suffered. And I just need to try to make a little bit more sense of all that, Your Honor. It might be premature for me to request that restitution be left to a matter of civil litigation. I may make that motion at some point, but I guess I would want to look over what Mr. Reeves has submitted, Your Honor, to the court.
What did Ms. Green already address the court, or did she decline to do so at the last hearing?
She did decline to do so, Your Honor, at the last hearing on the advice of counsel, Your Honor.
Okay.
We did offer, through counsel, she did offer an apology to Mr. Reeves. There's no contact between the parties. Children don't go to school there anymore. No reason for them to have any contact with one another, Your Honor.
Okay. All right. Okay. Now let me tell you all what I remember. I remember after the last hearing, and that's why I didn't remember that I didn't sentence Ms. Green, but now it kind of makes sense to me though, because I was so like appalled at the whole thing. Remember that the courtroom is not muted, please. I was so appalled at the fact that so, you know, some of the stuff that I was being told by Mr. Reeves, and then, you know, I was like, I'm not going to, you know, I need to see, I want all the medical bills and whatnot, because I remember I said, why wasn't this charged as a felonious assault? Because, you know, from what I had heard, I just knew it was something different. So now that you're telling me the first medical bill that you have is from 8 months after the incident, that's confusing to me. If you could try to not, I don't know, since you can't mute the courtroom, because it keep distracting me a little bit. Okay. So I mean, yeah, okay. I'm not, so now at this moment, I'm not persuaded. I'm not persuaded that the way that Mr. Reeves described the incident is the way that the incident occurred. I'm no longer persuaded. I'm no longer persuaded that whatever happened on January 18, 2019, I'm no longer persuaded that it resulted in injury to Mr. Reeves. I'm not persuaded. I'm no longer persuaded that whatever occurred with Mr. Reeves losing his job, I'm no longer persuaded that it had anything to do with this situation, because you have not identified any reason in close proximity to January 18th of 2019 that Mr. Reeves would have had lost wages and medical bills. So if the situation occurred in the way that I believed it to have occurred on the last date we were scheduled for sentencing, there would be some medical bills from January 18th, 2019. There would be a medical bill from some point in January of 2019, January 2019 medical bill. There would be a presentation of some lost wages due to having to go off work in January 2019. I'm reading the victim statement again on page 4. And when he spoke to Mr. Farmer, Mr. Reeves indicated that he has suffered tremendously. He wanted her to spend time in jail. He wants her to be held accountable. And then he said that he wanted her to reimburse him for lost wages and medical bills. And the court is not persuaded that a medical bill in 2021 has anything to do with 2019. The court is likewise not persuaded that some physical therapy in November of 2019 has anything to do with a situation that occurred in January of 2019 without any without anything in between there. If the situation occurred the way that I believed it occurred, then there would be some, like, you can't just get hit by a car and walk around for 8 months and then all of a sudden you need physical therapy. I'm confused by the presentation of restitution, the restitution request. I'm confused by the dates of the restitution request. So the court is going to impose the following sentence. There is a recommendation from probation to sentence Ms. Green to a probationary period of 12 months. The court is going to accept that recommendation as Ms. Green does not have any prior criminal history, and I am no longer persuaded that the incident that was described to me on the last date of June 23rd, I'm no longer persuaded that this incident was as serious as it was presented to me. Court is going to set a final review date of July the 17th of 2024. Ms. Green is eligible for early discharge after 6 months. The court is going to set a review for January the 18th of 2024. That review will be at 10 o'clock. The court is going to sentence or impose the following conditions of sentence. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without the consent of the court. You must make a truthful report to probation on a monthly basis, and you must notify probation immediately of any change of your address, phone number, or employment status. You will pay the following fines, costs, and fees: $210 mandatory costs, a $100 attorney's fee, a $200 fine. Court is going to, at this very moment, set restitution at 0. However, if I am presented at the first review hearing of any appropriate restitution costs, then the court will reconsider its decision. But I'm going to tell you right now, without some type of medical opinion from the doctor, that whatever injury that you're trying to submit a bill for from 2021 is directly related to the incident on January 18, 2019, I am not setting any restitution. Unless the court is persuaded of a direct correlation between some medical bills 2 years later from an incident that occurred in January 2019, I'm not going to set restitution. I'm not going to give restitution. I'm not going to order restitution for those items. That is too far removed. The November physical therapy is too far removed. Unless the court is persuaded by a medical doctor's opinion that whatever the physical therapy that occurred in November was directly related to what happened on January the 18th, I'm not going to include it in restitution. So at this particular time, the court will set restitution at 0. However, I am open to a restitution, to reopening restitution upon a proper proof that those bills are related to the incident. Supervision fees are $420. The pre-sentence investigation fee is $35. The total fines, costs, and fees for a 12-month probationary period is $965. If you finish within the 6 months, then you only have to pay $755 unless the court orders restitution. And then I will keep you on for the remaining 6 months while we address the restitution payments. Additionally, you shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription from the doctor and letter of explanation indicating why they have prescribed such an addicting narcotic. You shall not drive without a valid license. According to this report, your license is suspended and your status is ineligible. You shall complete 5 days of community service. That's equal to 40 hours. The court doesn't believe I read anything that alcohol was involved. Am I correct?
That's the people's understanding, Judge.
All right, so the court is not going to order the no alcohol. Additionally, I'm not ordering random urinalysis. However, she will submit to urinalysis today while she's in the building. And if there's any need for the court to be concerned, she did test positive for marijuana when she tested before and alcohol. But I don't even care about the alcohol. Of course, she will have no contact with complaining witness, Mr. Michael Reeves. And I am going to order the anger management 6 weeks through eBay. We will mail you a copy of the probation order to the Whitcomb Street address. Probation will contact you at the phone number ending in 8334. Oh, and I'm sorry, as to count 3, driving while license suspended, revoked, denied, count 3. Count 3 will run concurrently with count 1. However, the court is going to impose the mandatory cost of $185 on count 3, as well as a $200 fine on count 3. That's an additional $385. All right, anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Ms. Green. Thank you, Your Honor.
All right, Ms. Green, you're all set, ma'am. You have a great day and stay safe. Mr. Reeves, have a great day and stay safe. And I'm ready again on Barnes.
Your Honor, what was the fine on count 3? I'm sorry.
All right, I'm sorry. Let's.
Okay.
I'll send it to her, Judge.
Make sure they're not leaving out at the same time, Officer Krabs. I'm ready on Barnes, but I don't have you all said this is from yesterday?
I got it, yes.
Yes, Your Honor.
I don't have the docket. Can somebody read the case number for me?
I have 1105-535001, which is the people of state of Michigan versus Alicia Barnes, charged with count 1, operating while intoxicated, count 2, operating with a high blood alcohol content.
All right, and yesterday was set for what?
Yesterday was set for an adjourned final pretrial conference.
All right, appearances, please. Thank you, Ms. Stevenson.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Alicia Barnes. Good morning, Ms. Barnes. Ma'am, please tell the judge your full name.
Good morning, Alicia Nicole Burns.
Today is another adjourned date for the final pretrial conference. How are we proceeding?
So, Your Honor, it was Ms. Barnes' position that this matter had already been adjudicated through the sobriety court under Judge Lloyd. I did do some investigation. I did find a Z ticket around the same time as this incident date, Your Honor, but I didn't see anything in my review of the registers of action for the sobriety court case and for this case that there was an actual adjudication of this matter. So
this in the register of action. I probably didn't bring the paperwork I had on Ms. Barnes. I didn't remember she was coming back. And you said for this case, she was on the docket for a final pretrial conference?
Yes, it wasn't yesterday. That yesterday was adjourned from. Sorry, Judge.
No, that's okay. Let me try to. It's gonna take me a minute. It's a couple of step process for me to log into JIS from home, but give me a minute.
Okay.
This is something new. I never saw that before. Okay. Okay, give me the case number again.
1105 535001.
Okay. Offense date 2010. All right, let's see. Okay, in 2012, the judge was Judge Giles. And she failed to appear in 2012. She also failed to appear. So she was arraigned on a warrant in 2012. Then she failed to appear for her pretrial before Judge Giles. And then in 2015, Judge Lloyd was gone. Wasn't Judge Lloyd gone in 2015?
I think so.
Yeah, this case was not adjudicated in sobriety court. Then it was Judge Robbins. Judge Giles never referred this to sobriety court, and that wouldn't surprise me. So she may have had a case in sobriety court, but it wasn't this one. And then what happened with her case in sobriety court? Is she saying, yeah, and then this case has been in warrant status forever. Now, if she had a case in sobriety court. It could have been that Judge Giles said no to having his case heard in sobriety court. Sobriety court can't just take, the cases. They like to resolve all the cases that a person has, but if a judge says no, they can't. And that, according to the Register of Action on this case, it was never referred to sobriety court.
Yeah, it's only strange because the sobriety court case, that Z-ticket case, it was closed by Judge Giles on July 16, 2012. And there are entries from sobriety court prior to, with Judge Lloyd, prior to July 16th of 2012.
Okay, well, I'll need both registers, and I'll have to compare the dates. I'll have to compare, and I'll have to see why Judge Giles would do. Do we have the actual file for Ms. Barnes?
Checking now. Yes, we do.
Did Judge Giles write anything in the handwritten register about closing the case out?
Let's see. No, Your Honor, no notations.
Okay, so let me look at why Judge Giles would have any entries on the Z ticket, which would not have been before him. So let me look at the two. We can adjourn Ms. Barnes to Friday. Why did I make her come in person today?
My phone was
Say that again.
My phone yesterday on video Zoom was acting up.
Oh,
and
okay.
I did send Judge Giles that paperwork from Dickerson regarding something too when I was in Dickerson, them heights or whatnot.
Well, I'm going to look at it, and then what we could do is Miss Barnes can Zoom in on Friday. I'll look at, I need the register of action from the Z ticket, and I need the register of action from this ticket. Well, this is not a ticket, but from this case. So I need the register of action from her case with me, Ms. Silman, and I need the register of action from the Z ticket. I need to be able to print them out and compare it and look and see why Judge Giles would have any notation on the Z ticket.
Now, actually, what she just said makes sense, because if he was doing jail mail, it's still, yeah.
So if he was doing jail mail, though, he wouldn't have did this jail mail for the Z ticket.
Right, I agree with that. Yeah.
But I mean, I don't know what was going on back then. He could have did the jail mail and thought it was his case because he could have did the jail mail and thought it was his case. So I'll look at it and see, and then if she did jail time or something back then, I'll look at it, and then I can let you know Friday what I'm going to do.
Thank you, Your Honor.
All right, so let's adjourn Ms. Barnes to Friday, so I can look at those registers. You're welcome, and you can Zoom in, because even if you don't, if your phone acting up, Ms. Stevenson could tell you what my decision is, and then I can give you another date.
Yes.
All right, Friday at 9 o'clock.
Thank you.
You're welcome. Have a great day. Stay safe. All right, is that everyone in person? Hello?
I'm checking now. Yes, it is, Your Honor.